Good morning.
Good morning. I think I heard the answer to my question already, but I was calling about the unconstitutionality of the current practice where people that could be paying some money for their own health care instead wait until they get sick, they go to the hospital, they get their treatments, and then it's not free care. I mean, the doctors and stuff may feel like they're fulfilling their Hippocratic oath, providing care to the sick, but then they shove that cost onto my health insurance costs.
Randy Barnett?
Well, I mean, what you've heard so far is the argument that if Congress can make you deliver services to the poor, let's say, or to people who can't afford to pay it, or can make a private company do that, then they can also make the American taxpayer pay their money directly to those private companies to compensate them for it. And that's not a scheme that's ever been done before. When the government has offered services to people who can't afford it, and those services are being provided or being paid for by the general public pays for those services through taxes. There'd be nothing remarkable about that. What's remarkable about this bill is that for the first time, in order to avoid responsibility for raising taxes and enacting a government program, which was very unpopular, which is why they didn't do it, they decided to have people transfer their money directly to private companies. That seems to be, by the way, a very pro-corporate view. It was the way to get the insurance companies to buy in and support this program, because they were going to get all these customers in return for the cost they were going to incur as a result of the new requirements they're going to be placed on.
Randy, I think that you mischaracterized a little bit what the mandate does. The mandate is requiring people to carry insurance. And this is not taking money out of the pockets of the majority of taxpayers and putting it into the pockets of people who are poor. This is a protection for the majority of the people who are now paying insurance premiums, and as the caller said, those premiums, among other things, are covering the cost of uncompensated care for the uninsured. The mandate is designed to change that, and it is a protection for the rest of us.
So on that point, this is from a viewer in Buffalo, New York, saying, what's the difference between the health care mandate in this bill versus states' rights to require us to buy auto insurance or home property insurance?
Look, it's absolutely unremarkable that when you engage in activity, government at all levels can regulate the way you do that. If you decide you want to drive a car, then you have to get a driver's license and take a road test, and you also may have to get insurance in those states that require it. And there would be no challenge if Congress were actually regulating activity. And Justice Scalia, in the opinion that Simon cited with approval, used the word activity 42 times in that opinion. That's what the power the Congress has had exercised up till now. But now Congress is seeking to exercise a new power it's never tried to exercise before, and that is to mandate activity, to require you to. I represented Angel Rach in the medical marijuana case, where the federal government said that she could not have, possess, or cultivate marijuana. But the federal government, and the federal government's power to do that was upheld in the Rach case that Simon is talking about. We lost that case 6-3. But the federal government never mandated that Angel Rach grow marijuana. That was something that would be so far-fetched a power that no one even thought to exercise, that it had that power until 2010 when it passed the Affordable Care Act. It's a new power.
Sasha has a Twitter directed at you. Is the Georgetown professor a strict constitutionalist?
I believe in following the Constitution accurately. I don't know that strict adds anything to the fact that we just need to follow what the Constitution says. And I think that, by the way, I don't equate what the Supreme Court says with what the Constitution says. Although in this litigation, we're simply founding this litigation on what the Supreme Court has said about the Constitution, not what the Constitution actually has said.
Our focus is a number of legal challenges at the health care bill that the President signed into law last March. Stephen is joining us from Silver Spring, Maryland. Good morning on the Democrats line.
Good morning, gentlemen. My question I had for Randy Barnett was just answered. It was about the difference between a mandate to buy auto insurance and, you know, this health care deal. But I just wanted I don't think he elaborated on the question quite clearly. I would like to know exactly what he thinks the difference is by them requiring you, because if I'm correct, at least 50 of the states require that you have to have auto insurance.
Right, but they don't.
And Daniel says the same thing, that car insurance is an option since you don't have to have a car, and it is the state's right to do this, not the federal government to make them.
Right. They don't make you buy a car. They don't make you drive a car. In fact, if you drive a car in those states on private property and you don't go onto the public roads, you don't have to have car insurance for that either. And you only have to have car insurance to insure the injuries that you inflict on other people. You don't have to have car insurance to protect yourself. So this is. The point is that Congress and the states all the time tell you how you're going to engage in activity if you choose to engage in activity. But in this case, they're making you engage in a transaction, and that's something that Congress has never tried before.